Welcome to CivilCoursify. Download the Android app and subscribe to our channel on YouTube. Don't forget to hit that bell icon to get instant access for all the videos. Also follow us on Facebook as well as Telegram. In this video, we'll talk about the Supreme Court's verdict declaring right to privacy as a fundamental right, and then we'll understand the basic concepts of fundamental rights, Article 21, and privacy. And finally, we'll look at the way forward. Alright, let's begin. Now, the Supreme Court gave a decision on the 24th of August 2017 saying that the right to privacy is a fundamental right. Now, let us look at what exactly this meant. This verdict was given by a 9-judge constitutional bench with a 9:0 verdict, which meant that it was a unanimous decision, with all the judges saying that Article 21 should be made a fundamental right. Now, the Supreme Court said that the right to privacy is intrinsic to right to life and personal liberty granted under Article 21 of the Constitution. About 50 to 60 years earlier, there were two earlier rulings. One was the 8-judge bench of 1954, and the other was the 6-judge bench in the Khadak Singh case of 1962. Both these rulings said that Article 21 should not be made a fundamental right. But the latest ruling of 2017 has now overruled both the judgments with a higher constitutional bench of 9 judges, and finally, Article 21 is made a fundamental right. Now we come to the question of why there was a need to bring this verdict at this point of time. So let us go back in time for about 1 to 2 years back, where this Aadhaar issue had started popping up, and there were a lot of issues, a lot of challenges where the government wanted to bring Aadhaar as a mandatory service, and Aadhaar data was to be used by the government for various welfare schemes, for various social welfare schemes, and there were a lot of petitions filed in the courts which challenged the mandatory use of Aadhaar cards. Now, the Aadhaar cards, as all of us know, that they provide a unique 12-digit ID to every citizen. Now, the Aadhaar database links the iris scans and the fingerprints to more than 1 billion people. And the issue of this privacy had emerged when the apex court were dealing with a batch of petitions challenged the government's move to make biometric Aadhaar mandatory for availing the benefits of various social welfare schemes. Now, there were a lot of fear that data could be misused by the government and other private agencies as well, and there was no right to privacy as the people had given their data to the government and the government had outsourced it to various private agencies. Now, there were recurring reports of Aadhaar details being leaked and a lot of theft. So, although UIDAI has said that its data is secure, but still it is a matter of debate and it is there in the court. So the 5-judge bench hearing the Aadhaar case referred the issue of right to privacy to a 9-judge constitutional bench. As I just said, that the earlier ruling on right to privacy was by a 8-judge bench, and to overrule the judgment, a numerically superior bench was required. Now let us look at some important points about this concept. The first one is that the bench has decided in favor of a fundamental right to privacy existing under the Indian Constitution. This bench did not decide the fate of Aadhaar. Only the nature and status of the right to privacy under the Constitution has been talked about. So Aadhaar has not been talked about at this point of time. It does not comment on whether the government's demand for Aadhaar to be linked to all the financial transactions amounts to an infringement of privacy. These decisions will be taken by a separate and smaller bench of a 5-judge constitutional bench. This is a case that is being heard by a 5-judge constitutional bench, and this bench will decide about the fate of Aadhaar. Right now, this 9-judge constitutional bench has only decided about Article 21 being a fundamental right. Now, for beginners, let us have a quick recap of the basics of fundamental rights. The fundamental rights are enshrined in Part 3 of the Indian Constitution and are mentioned in Articles 12 to 35. They are justiciable in nature, that is, they are guaranteed by the courts to all the individuals equally. Now, if any citizen feels that his fundamental rights are being taken away by a public or a private organization or by any other citizen, he can simply move to the courts, and the courts would ensure that he gets back his fundamental rights. They prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedoms of the people against the invasion of the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. So these are virtual self-defense mechanisms in the hands of the citizens, and they prevent authoritarian and despotic rule by the executive and legislature. Now, Article 21 talks about protection of life and personal liberty, and it declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. The Supreme Court has reaffirmed in the Menaka case and subsequent cases that various other rights automatically fall under Article 21, although they have not been mentioned in the Indian Constitution. Some of these rights are mentioned here. Now, what all comes under privacy? Now, privacy does not have a precise legal definition. Some legal experts define privacy as a human right. International charters like the Article 12 of the Universal Declaration of Human Rights protect persons against arbitrary interference with one's privacy. Privacy can mean a range of things: the right to be left alone, freedom to dissent, or protection from state surveillance. Now, what should be the way forward? We live in an era where the right to privacy is not absolute, and every day we use the internet and other technologies to such great extent that all of us are part of the big data world, where a lot of data transaction is taking place every single second. Technological advancement is required to cater to the growing demand of social, economical, and intellectual development of the society. Technology cannot advance without involvement of its users. Hence, although right to privacy is a very important part of our lives and should protect us from data thefts and deliberate spying by the state and private agencies, there should be some basic regulations to help the technological community thrive. Now, some issues that might arise now are Aadhaar not being mandatory, Section 377, and WhatsApp's new privacy policy. So this is it for this video. The PDF notes for this video are available on the CivilCoursify Android app for free. Subscribe to our YouTube channel, download the CivilCoursify Android app, and follow us on Facebook and Telegram. Links are available in the description as well as comment section. Till then, thank you and take care.